This morning's docket. Case number 109080, State of Kansas v. Sellers.
May it please the court, Michael Whalen on behalf of the appellant Jerry Sellers. With the court's Chief Justice permission, I would request 5 minutes of rebuttal time.
5 minutes is granted.
This court in the Mitchell case, I don't think the intent was to exclude all statutory means of access to the courts by incarcerated persons. That's going to be the first issue that I address today. The second issue will hopefully be looking at Portillo and its application. At this point, at least as far as I've seen, the Court of Appeals has stopped dismissing cases as a violation of the Mitchell case. This court's well aware of the language in Mitchell. There's a line that stated that KSA 601507 is the exclusive remedy for inmates to have access to the courts. And at least, I don't know if it was a panel or a particular judge or the chief judge, took that language in particular to dismiss a number of pending appeals based upon that language. I think out of my office we had 3 or 4 that were directly dismissed based upon that language in Mitchell. Now, I am assuming that it was based upon that language in Mitchell because that was what the show cause order referenced that we responded to. The appeal was then dismissed without comment. I don't believe that that is still the current practice, and unless the court has questions about that issue, I would like to address the Portillo Act issue.
Proceed.
Thank you, Your Honor. In Portillo, and this court found that if a district court becomes aware of a defective complaint, that it could address that and it would be reviewed under the analysis of pre-Hall.
That was long before an appeal had been taken, though, in Portillo, right? Portillo was a really odd case.
I don't think so, Your Honor.
Don't you think it's odd that the prosecution would go clear to sentencing before it would reveal to the defendant that they were seeking, that they had prosecuted an off-grid rather than on-grid? You don't think that's pretty unusual?
Quite honestly, I don't find it any more unusual than asserting a Jessica's Law case without putting it in the complaint, the instructions, and having any review by the jury, and then allowing an appellate court later on to say, reasonable doubt was there, we have it figured out for them. Because I don't think that's the position of this court. I recognize that there are, especially under Nieder, the analysis that this court has issued, that if the court finds beyond a reasonable doubt that there were facts that would have been found beyond a reasonable doubt by the jury, that this court or an appellate court can make that finding.
That argument's never been made on behalf of Mr. Sellers, has it?
That's not one that we've gotten to in this, but I think
the only thing we're talking about today is the defective complaint issue, right?
Yes, Your Honor.
So let's just assume a few things for purposes of argument. First of all, there's jurisdiction of the appeal. That was your first point, which
yes,
nobody had any questions about. Okay. Let's also assume that you can use this procedural mechanism. I mean, you can file a motion, which is really supposed to be the time-limited path, but you can file a motion, you can get before the court. Let's just assume you can do that for now. And let's assume the pre-Hall standard applies somehow, through a miracle. Why would this complaint be defective? It listed his birthday, and anybody who can, as Bill Clinton has alluded to, do arithmetic can figure out that this gentleman was 35 or 36 years old at the time of the crimes. Isn't that correct?
Well, it was in the heading.
Okay. Well,
Not
that
part of the
crime,
charge, not part of the notice.
right,
Under 223202, I believe, is the statute that has to do with the prosecutor begins the prosecution in a case, or a case commences with the filing of the complaint and service upon the defendant. We're not talking about something that's that difficult.
I know that, and I appreciate that. I'm just saying that that complaint did contain his birth date. And there was no way that anyone who read that complaint could believe that the person accused was less than 18 years of age. So why doesn't that, if we assume all those other things for the time being, why doesn't that satisfy the pre-Hall standard?
Because
For
it's
the
not a matter
complaint
of
being
what
adequate.
might be in the heading. It's about what the state has charged the defendant with.
Okay.
And the
Being in the
elements
heading
must
isn't
be
enough.
listed. I mean, if we go to a critical analysis and go pre-Hall,
That's what I'm asking for.
every element must be listed in the charge.
Okay.
And putting it in the heading isn't going to cover it. There's no difference in the analysis of this and any other charge or any other element that is being filed against the defendant. The obligation of the state, what they are paid to do, is to see that the charge is in the language of the statute, includes the elements, and gives full and proper notice of the charge and allegation against the individual. That's what this court has said. On an arrest of judgment motion, that's the analysis and how this court would look at it, or how the district court would be required to look at it. Was an element there? No. And then we go to, and I think this is kind of where we get into the argument of this court making findings of fact. The jury instruction, what was given to the jury, did not include a requirement that the jury find beyond a reasonable doubt that Mr. Sellers was over the age of 18.
We're not here today about the instruction.
Yeah, we are, Your Honor. That's the second argument that in my case, that the Portillo analysis should apply to and be analyzed on the jury instructions.
Are you asking us to overrule Reyna? Is that what your State v. Reyna?
Well, I think it should happen.
So
I think legally,
we should just ignore the Nieder, U.S. Supreme Court Nieder line of cases that Reyna relies on. You're asking us to take another look at that and
well, there's
reverse what we've done for the last 4 years.
Yes, in short. In particular, the facts of this case. On direct appeal, this court specifically made the finding. In this case, the charging document did not allege that Sellers was 18 or older at the time of the crimes. It did list his year of birth as 1971. There was no evidence of Sellers' age admitted at trial, other than whatever circumstantial weight could have been given to a passing mention of his military service with MRC's mother. The jury instructions on the elements of aggravated indecent liberty offenses charged in counts 1 and 2 did not inform jurors that they must agree that Sellers was 18 or older when he molested MRC. This court's prior factual findings, or at least, well, it wasn't the listing of the facts. This was under the argument that was made regarding 36 months post-release versus lifetime, which was the only issue raised in the direct appeal as it related to this question. If defense counsel, alternatively, had made arguments to the jury at that time, ladies and gentlemen, have you heard any evidence that this gentleman was over the age of 18? Have you heard anything? The burden is on the state to prove beyond a reasonable doubt that Mr. Sellers is over the age of 18. Have you had any such evidence presented to you by the state? Because you have not, you must acquit. That would have been the law. And I know there would have been counter arguments had it actually been included in both the complaint and the jury instructions. everybody would have been on notice, and quite honestly, the state might have put some evidence on about that, but they didn't. So how can an appellate court say, beyond a reasonable doubt, he was 18 in a situation like this?
Can you point out to me in your petition for review where you raised the jury instruction? I see it in your conclusion.
Page 11.
I see it in your conclusion.
Page 11,
Okay.
where
So
TO applies to the
Even though
defective jury
you're-
instructions.
even though you're really attacking whether they made a mistake on whether they had jurisdiction, that's the issue on which your review is sought.
No,
You're-
Your Honor, there were two issues.
I know there were two issues in your Court of Appeals brief, but the only issue you list as the issue on which review is being sought is whether they erred by finding they lacked jurisdiction.
Well, the prayer for review is a little deficient on that, Your Honor.
Okay.
I guess I would say that was
At least
mistaken.
confusing.
Yeah, and I do apologize. However,
Okay.
the arguments and authorities as well as the request for review apply to all the issues that were presented in the supplement of the brief.
Thank you.
And
Justice Barr assumed that we could use this procedural mechanism, but I'd like to tell you, or like you to tell me, why a defendant has any right to appeal under a statute that gives the court authority to do something sui sponte when the preceding statute specifically provides a mechanism for relief for the defendant. In other words, 3502 provides a basis by which your client could have filed a motion to arrest judgment. 3503 tells the court what it has authority to do. So why does your client accrue any rights under the court's authority statute? You understand what I'm asking you?
I do, Your Honor. The only
In
requirement
other words,
under that,
why can you do under 3503 what you could not do under 3502? That's the bottom line.
yes, Your Honor. 3503 states that if a court becomes aware, I made the court aware. It doesn't say how the court becomes aware. It's not a matter of judges going back through prior complaints and saying, you know, I think this one's wrong. I'm going to go ahead and call a hearing. And there's also not necessarily a means for a court to do it. Now, the alternative is I could have filed a notice of the court of a defective complaint. But if the court chose to take no action, I would have no basis for appeal or for that matter to be reviewed. 3503 does not say the court must have the knowledge miraculously placed in its head. It doesn't say how the court becomes aware. I took the positive step of making the court aware.
Through
And
a
I don't think
motion,
there's a bar under
excuse
this.
me, through a motion filed by the defendant, which is covered by 3502, the more specific statute.
Well, I think there it also says that a defendant may file, and there's a time limit on it.
It does.
Yes,
So why isn't 3502 the controlling statute rather than 3503?
they're not in conflict, Your Honor. They both stand independently. And 3503 doesn't give a mechanism of how a court becomes aware. Merely that the court becomes aware. And the court was aware when it received my motion. And there isn't a fight that we have to choose one over the other. And I don't think it's a statutory construction question. Because if, I think we see by 02, that the legislature knows how to set parameters for information to get before the court. That is one method. The other method is the court becoming aware. It does not exclude or define any particular means of knowledge of the court's awareness. One doesn't cut out the other.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up?
I think this court, one, we need a written decision that Mitchell should not be applied across the board to exclude access to the courts that are provided for statutorily. Two, the statute does not prevent knowledge of the judge coming in this manner, and the analysis should be pre-Hall, and that it was deficient both in the complaint and the jury instructions as to how this case was presented. Thank you, Your Honors.
Do we have any questions of counsel? Thank you.
Ladies and gentlemen of the court, good morning. I am David Yoder. I'm the Harvey County Attorney in exciting Newton, Kansas. I was the prosecutor in this case, and I wanted to preface this by stating this was our first Jessica's Law jury trial that we ever had in Harvey County after it was passed. So this is obviously a learning experience. Cases coming down from the August appellate courts made it clear, and it was a lesson learned that we need to make sure that the defendant's age is proven to a jury and that a jury makes specific findings of the defendant's age. This was addressed on appeal. It was worded in the area of a lifetime post-release, but it was addressed on appeal. The defendant, at the time of sentencing, we charged the case as a Jessica's Law as an off-good. Yes, ma'am.
Let me stop you for just one
Yes,
second.
ma'am.
I just want to be clear about what was and wasn't addressed on the direct appeal. There wasn't a specific issue raised by the defense of the direct appeal about his age.
That is correct. It actually was raised and addressed in the area of lifetime post-release and how that would apply.
It was
How
mentioned.
Jessica's. I'm sorry.
It was mentioned in the opinion, but it wasn't
yes,
raised
yeah.
by the defense.
Yes, and I handled the appellate case, and it was specifically discussed at that point in time with the appellate courts about the defendant's age and not being proven to a jury. The remedy of that is not dismissal; it's sentencing under a guideline sentence, which is exactly what happened. The court did at the time of sentencing deported to a guideline sentence. So the defendant did get the remedy of the fact that it wasn't proven to a jury. He did, in fact, get a guideline sentence.
He got a guideline sentence, but they start at a different point when
Yes,
departing.
Yes, ma'am.
And that's the injury. And it's obvious that to the extent some arguments have been made about the instruction or a failure of proof today, that the remedy is different from the remedy sought today, which is that he walks.
Yes, ma'am, and I couldn't disagree more wholeheartedly with that. That's not what we're here for today. What we're here for today is an appeal by the defense of the denial of the court or a declination of the district court to apply a remedy of the court's own motion under KSA 22-3503 to arrest the judgment on the court's own motion. As has been pointed out here, the defendant lost the ability to file a motion to arrest judgment under 3502 on his own because the time frame for filing that motion to arrest judgment had long since passed. So the defense attempted an end around basically by asking the court on its own under 3503 to arrest judgment. District Court Judge Dickinson reviewed it, declined to do it, and said in a written opinion, I am not arresting judgment. The defense is now attempting to step into the shoes of the district court because they can't do it under 3502 because that statutory time frame has passed. So they're attempting to step into the shoes of and the authority of the district court by wording this around as a 3503 when it's by statute. That is the district court's option and right to do under 3503. The defendant, it's our position, has no standing to try to arrest judgment through a 3503 and attempt to arrest judgment when his statutory remedy under 3502 has long since passed. As Mitchell, the state takes a position that Mitchell should apply in this case because even though Mitchell dealt with a 6260 motion, the principle is the same. The defendant cannot do an end around by bypassing the time limitations of a statute. And 6260, his time frame for filing a motion under that for post-conviction relief, he had a 1 year statute, 1 year statutory limitation to file a 6260. He failed to do so within that period of time. And Your Honors in Mitchell stated that the remedy in that is to file a 1507, and that's the exclusive remedy once the statutory time frame to file such a motion is passed. Now, the defendant in this case did file a 1507 after we went through all the appellate processes and the convictions were affirmed. He did in fact file a 1507. Did not at that time allege anything concerning a defective complaint. Instead, the 1507 there was challenging effectiveness of counsel concerning not hiring a forensic expert to question the forensic interview of the child victim. And that was denied by the court, and the Court of Appeals upheld the district court's finding. At no point in time during that 1507 was there a challenge of the defense attorney's failure to pursue an arrest of judgment under 3502. So now that the time frame for filing a 1507 has passed, challenging the attorney not pursuing and filing a motion for a 3502 arrested verdict, then what the defense is trying to do now is step into the shoes of the district court and say, well, we're going to do it now through a statutory authority that we don't have.
Counsel,
And we believe Mitchell applies to that, would apply to prohibit that. Yes, sir.
I'd like to go back to, some discussion between the court and opposing counsel a few minutes ago about these two statutes. And
Yes, sir.
I'd like to ask, in your opinion, what is the purpose of 3502 if you can rely instead upon 3503?
Well, Your Honor, the purpose of 3502 is if it comes to the defense attention that they believe the complaint is defective in some manner, then they have the right to file a motion to arrest judgment on that case.
Doesn't 3503 cover everything?
Well, no, Your Honor, I don't believe so. I think
Per the argument of opposing counsel, doesn't it cover everything?
well, that's what opposing counsel is trying to state. Yes, sir, but I disagree with that.
And I'm asking, therefore, why do we have 3502?
Well, 3502 is designed specifically to give the defendant an exclusive remedy for filing a motion to arrest judgment, but sets a very specific limited time frame in which to do that. If for some reason the district court on its own takes a look at the complaint and decides that there is some sort of defect in the complaint, then the court can on its own motion at any time, because there's not a limitation of time on that, can on its own decide to arrest judgment. Now in this particular case, the defense asked the court to do that. The court took a look at it and declined to do it. So the defense is trying to now step into the shoes of the district court and appeal something that the district court denied when, this is not challenging. There's nothing in the motion or the appeal by the defense where they are trying to question or ask the appellate courts to reconsider the district court's findings. They're trying to step into the shoes of the district court itself and appeal and attack and the charging document on its face through basically a 3502 that they no longer have the authority to do. Jurisdictionally, I don't see how they can stand before here and ask for the remedy that they're asking for. They're attempting to apply Portillo, which I agree is a queer duck case in the sense that in Portillo, the county attorney erroneously charged the case. Well, they charged the case as a level 1 person felony sex offense case. They never at any point in time alleged a Jessica's Law a sentence. They never alleged an off-grid felony. They alleged it as a level 1 felony. They went to court, didn't produce any evidence at court of the defendant's age. And then when it came to sentencing, they took a look at it and go, oh, well, this should have been a Jessica's Law case, so they're then asking for a Jessica's Law sentence when they actually charged it as a level 1 felony. And in that case, I'm sorry, yes, sir.
the facts are just flipped here, if I understand it. The district court sentenced as an on-grid offense.
Yes, sir.
And it seems to me the complaint was not defective in any way with respect to the on-grid crime.
That's my position, Your Honor. Yes, sir. My position is we
And so
placed...
neither 3502 nor 3503 are apropos here under pre-haul, post-haul, whatever, because there were no missing elements. There was no defect in the complaint with respect to the on-grid crime for which Mr. Sellers was sentenced.
That is exactly the position that I am taking, is that the complaint was not defective in any manner. If you look at it under any analysis, under Reyna, under Inkelar, under all of the Hall and post-Hall cases, it's very clear that we satisfied those requirements to show that the complaint is not defective. The defendant's age was specifically listed on the complaint. It was specifically listed that the child's age was listed.
But age is not an element of the crime for which he was sentenced.
Yes, sir, that is correct.
Okay.
Yes, sir, that is correct. But as far as the underlying charging documents, the state's position that the underlying charging document was not defective in any manner. What the issue became was at trial, the state did not present evidence proving the defendant's age as being over the age of 18 to a jury beyond a reasonable doubt. So the remedy was exactly what the defendant got, was a guidelines sentence. So the state's position here, under any analysis, is the complaint was not defective. The district court was absolutely correct and not on its own under 3503 arresting judgment because there was nothing defective in the complaint. And the defendant has no standing at this point in time to challenge that. I stand for any questions.
Any further questions? Thank you, counsel.
Thank you.
Counsel, before you begin your prepared remarks, I'll ask the same question of you that I ask opposing counsel. Under your interpretation of the statutes, why does 3502 exist if you can just go straight down to 3503?
Flip it around. Why does 02 exist if you have 03? If a judge can fix it at any
what I'm
time
asking.
upon their own,
That's what I'm asking. Why have 3502?
I'm saying the opposite is the reverse is also true. You have an overarching statute that allows for it to be fixed at any time upon notice to a judge. And what is notice? In the alternative, it is correct. I could have merely filed notice to the court that there is a defective complaint, waited some time to see if the court took any action, and if they didn't, file a motion to compel
Let's
court.
go at this a little different, Mr. Whalen.
Okay.
One of our rules of construction is that we do not construe in order to make a legislative provision superfluous or meaningless. Isn't that one of our rules of construction?
Yes, Your Honor.
And I think what the chief is asking is if we construe 3503 to allow defendant to file a motion to make the court aware, then that renders 3502 meaningless or superfluous in contravention of our rules of statutory construction.
I think statutory construction, a greater base is ordinary words, ordinary meaning. And 03 says if the court becomes aware. No limitations on that.
The last two words of 03 are without motion. The 03 applies when the court becomes aware of the existence of the grounds without motion. And I think you're asking us to read those two words out of that statute.
But even within motion, it's, I think, a logical inconsistency. Because if you make the court aware, and the court becomes aware,
When
because
you make
then
the
we're
court-
mincing words about filing just a notice of defective complaint. Dear District Court, here is notice of a defective complaint. That would satisfy the statute, as long as it wasn't per a motion.
But that isn't what happened here, is it? You filed a motion,
I did file a motion.
and it says whenever the court becomes aware of the existence of grounds, blah, 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 the court may arrest the judgment without motion. I think you have to read those two words back in as a predicate to the triggering of the statute.
But then do you undo the awareness of the court?
I'm struggling to understand when it's appropriate, what the policy is of 3503 for a court to sua sponte decide that, oh, wait a minute, this complaint is defective. I mean, what was the goal here? Do you have any sense of that?
Of the statute?
Of the statute?
No, because I don't understand it either.
Yeah, I mean, it really puts the
And
judge
absent, and it really does, it kind of suggests, cold case file district court activism of, I'm going to go back and take a look and see what's there. Hey, how else does one become aware of it? And I think that is the question.
Can't it also be read to suggest that the awareness will arise while the matter is still pending before the district court? Sometime during trial, sometime before sentencing? Isn't the court likely to become aware when it has the file in front of it?
In order to give the court the ability to sua sponte fix a defective complaint.
Right.
So why would you do that 4 years later? I'm sorry, I interrupted. Proceed with responding to Justice Byers' question.
That's okay, I'm trying to split my thoughts right now. I guess that it could be applied in that way, but this is still a jurisdictional question, in my opinion.
Well, I'm sorry, I don't understand that. I thought that at the very beginning you said there wasn't a jurisdictional issue.
No, I mean as far as, such as in the Portillo, if the complaint is defective, the court never gains jurisdiction to sentence the individual or for the conviction to occur. And so you can't restore that and go back and restore that. And I'm saying the defective complaint is a jurisdictional infirmity in the original criminal case.
I'm with you.
Okay.
And when you filed your motion, let's take a look at what the district court was aware of, which it was aware. It was aware that it had sentenced Mr. Sellers to an on-grid offense. It was aware that we had case law out there that says if the age is missing, then you don't dismiss the case for lack of jurisdiction. You remand to resentence for the on-grid because it's not defective with respect to the on-grid. And it knew that it had sentenced for that on-grid crime. So what part of the complaint would the court have been aware that was defective when all the elements of the crime for which the court sentenced Mr. Sellers were contained in that document?
Two responses to that. Number one, he wasn't sentenced for an off-grid crime. He had life sentences that there was a departure from. So the court had to make specific findings and ostensibly substantial and compelling reasons to not impose a 25-year mandatory life sentence. So it's not that the court wasn't compelled to impose that sentence. Based upon a special request by the defendant and special findings, that sentence was imposed. So that's not really the case. Two, prosecutorial discretion. What charge are we going to file? What do we think we can prove? It is completely up to the discretion of the prosecutor as to what conviction they are going to seek. In this case, their representation was, we are seeking a life sentence. We are seeking a specific crime with a specific element of the age of 18. They did not charge that. The jury was not aware of it. And there was not a finding by the jury of an element of the crime. As such, The charge that was filed and sought by the state, who had the responsibility for authoring, in the language of the statute, the charge failed to do so.
And
And
you will-
therefore,
You will agree that those cases where we have found that to be the case, that the element of age was missing, and there was no proof, that we haven't dismissed.
correct. And but the question hasn't been based upon the defective complaint. Those cases did not go back to it being analyzed as a jurisdictionally deficient complaint.
So we made the mistake, because we're supposed to consider jurisdiction sui sponte. So we just made a mistake on those cases by not recognizing that there was no jurisdiction.
Well, I don't know that you're required to sua sponte consider jurisdiction. You have the ability to sua sponte consider jurisdiction. And yes, I think this court could have. And I think following Portillo, and this issue being one of notice to the district court, and be able to review a defective complaint under the pre-Hall standard, was the intervening law that changed how these cases can be approached. Because it's not the same as Reyna, it's not the same as Garza, it's not the same as Aguilar. This is a completely different argument. And it is a brand new argument. And it is a matter of first impression. I don't know that any of these other cases have been filed.
Mr.
It
Whalen,
seems to
can
me
you,
that-
oh, excuse me.
It seems to me that likely the justification for 3503 is what you've just been discussing, and the court's ability to sua sponte read subject matter jurisdiction on its own. And as you pointed out, often that doesn't happen, and you've said we don't have to. Given that, what is our standard of review if a district court is aware of a problem and declines to dismiss because of subject matter jurisdiction?
It would be unlimited because it's a question of law and jurisdiction.
What factors do we look at, though? I mean, if the court, if we've just talked about a series of cases where we have not dismissed for subject matter jurisdiction, how does that happen? Is there a balancing of factors? Or is it just, it's an absolute, if it's been brought to the court's attention and they don't do it, it's automatically reversible?
It'd be the same as if an arrest of judgment had been filed.
So no discretion is what you would
Correct.
argue.
Not
And-
once
and-
the
and I
court's
would-
aware of a
I-
subject matter jurisdiction.
I'm sorry, Your Honor.
Not once the court's aware of a subject matter jurisdiction problem. Then there's no, you're saying that it doesn't have to do it sua sponte. It's permitted to do it sua sponte, but once it's been brought to its attention, if it has merit, then it must be dismissed for lack of jurisdiction. Okay, I'm following you there. Was there something else you wanted to add? 'Cause I
No,
have
that
a
was
question.
actually the statement I was going to make.
Okay.
was-
Here's my question. You've mentioned Reyna, and there's Reyna, Gonzalez, Gracie, Huerta, Alvarez. All of those cases were ones where there was either a failure of proof or failure to instruct or both on the age 18. But they were cases that were where the complaint was reviewed under the post-Hall standard.
Correct.
So here's my question. And the court said birth date in the caption is good under post-Hall. So are we in agreement that in order for you to prevail today and to get the relief that you want, we must apply a pre-Hall standard?
Yes,
Okay.
I do agree with that. And that's a very fair statement of the law. And, I think it's time to bury Hall, if I can go back to a concurrence from earlier this year.
But you came
That's
to
not-
argue something else, not to bury Hall. Okay, paraphrasing.
Actually,
Okay,
I came to bury Hall,
you came
not to
bury
praise
Hall,
it.
Not to praise it. There we go. Thank you.
And I'm out of time unless the court has other questions.
Any more questions? Thank you, counsel.
Thank you, Your Honors.
Thank you both for your arguments this morning. Court will take this matter under advisement.